So let me kick it over to Renee to introduce our speakers. Renee.
Thanks, Jean. On our panel today, we have Scott Jarrett. He's a partner at Haynes Boone and a nationally recognized PTAB practitioner. Ranked among the top 1% of PTAB attorneys, Scott leads high stakes IPRs across cutting edge technologies and previously served on the board of the PTAB Bar Association. Next, we have Bukola Landis Aina. She's an associate general counsel at Verizon, where she leads strategy for complex patent litigation and IP risk. With nearly 2 decades of experience across in-house and AmLaw firm roles and an MIT engineering background, she brings a pragmatic, business-focused perspective to IP disputes. Next, we have Lisa Mandrusak. She's the Senior Associate General Counsel at Roku, where she leads global IP strategy and complex litigation matters. Her experience spans patents, privacy, licensing, and enforcing, making her a key voice on in-house IP decision-making in fast-moving technology environments. And last but not least, we have Jordan Rosen. He's a Senior Patent Counsel at Unified Patents, with experience representing clients before the PTAB, ITC, district courts, and the federal circuit. With a background in chemical engineering, Jordan brings a practical and approachable perspective to complex technical disputes. So this is an amazing panel that you have today. Back to you, Gene.
Great, thanks a lot, Renee. And I'm going to kick it right over to Scott to moderate, to go through this. What I will just ask you all in the audience, if you have a question that you would like to pose to the panel, please use the Q&A feature here on Zoom. Feel free to use the chat feature to chat amongst yourselves. So far, the chat has been quite active and at times even heated. So we encourage you to chat amongst yourselves there, but it will be just a little bit too much for the panel to keep track of everything that's going on in the chat. So questions for the panel, please, in the Q&A box. Scott, take it away.
All right. Thank you, Gene. And thank you, Renee, for putting this panel together. And thank you, Lisa, Bukola, and Jordan for taking time out of your busy days to share your views. And I should note that the views shared on this panel are the panelists' personal views and not necessarily the views of the respective companies. And so like Gene said, the purpose of this panel is to present more of a petitioner-side assessment of the recent changes to the PTAB. But to hear what the stakeholders themselves think, right? Those that have actually relied upon IPR in the past to defend themselves. All right, so let's get right to it. So the title of this panel is IPR on life support. So I'll put it to the panel. Are IPRs really on life support? Do you agree with the title of the panel?
Sure, I can take that. I would say that IPRs, from the perspective of a defendant in patent litigation, I would say IPRs are in an administration-induced coma. They're not on life support simply because they're not dying. Like, the statutory framework remains intact. I'd say that as long as the law provides for this set of procedures, petitioners who find themselves in the position of being frequent defendants will be able to use it again at some point in the future. Maybe not anytime soon, but when you interview jurors and mock jurors, they consistently convey that they're not the best equipped to determine whether or not what the patent office did was right. It's truly the patent office that's in the best position to do that, and so we continue to look to the patent office to be the one to make those determinations.
I would just echo that completely. I don't think IPRs are dead, but they are on the verge of being completely irrelevant. And that being said, at Roku, IPRs have been pretty relevant for the last 5 years or so anyway, because our institution rate, statistics, generally notwithstanding, our institution rate has hovered below 10% for the last several years. So this landscape is nothing new to us, but welcome to the party to everyone else.
And I would generally agree with what everyone is saying. They're not dead, but they're definitely sort of on a hiatus a little bit. I think the numbers show that the filings are down and will likely continue to be down as long as sort of the current implementation goes forward.
So speaking of numbers, I think given that things have shifted so much, I think it would help to kind of quantify the actual scope of the change with some numbers. So Unified Patents recently conducted a statistical study and put together a report that was released earlier this month. Jordan, do you mind discussing some of the report's highlights?
Yeah, I think sort of the one of the big things there that has to do with the PTAB is that discretionary denials from 2024 to 2025 went up more than 630%. So that's obviously a huge jump caused by the, the different approach of the new administration. And I think largely because of that, you've seen PTAB filings down about 6% year over year. And I think that severely understates sort of the decrease just because, that's covering the beginning of 2025 when PTAB filings were actually higher than they were in 2024, the first half of 2024. I think it was the second half, and especially the last quarter where PTAB filings have just really dropped quite a bit. And because of that, I think you've seen an increase of re-examinations. I think they're up 66.1% year over year from the last year. So taking up some of that slack, some people are moving from IPRs to re-exams. And so in 2025, actually, ex parte re-exams made up about 36% of all post-grant proceeding filings, which is up significantly. I think 2024, it was a much, much smaller percentage. And then I think also you can sort of draw a line there with the increase in district court filings over the last year. I think district court filings are up 12%, and specifically NPE filings were up almost 22% over the last year. And some of the biggest increases were in the Eastern District of Texas and the Western District of Texas, where I think 44 percent of all NPE filings in 2025 were in the Eastern District, with another 17% in the Western District.
Thank you, Jordan. So clearly, numbers-wise, things have changed very quickly, including, as you mentioned, an increase in non-practicing entity activity. So kind of let's talk about what that means for American businesses such as Roku or Verizon. So Lisa and Bukola, I'd love to get your thoughts on how IPR becoming less accessible has affected U.S. companies, and maybe even your personal day-to-day life as in-house counsel.
I mean, it's significant. We no longer have this critical tool to defend us against NPE assertions, which are the bulk of assertions that Roku faces. And I will say, though, that like Jordan noted those district court filings going up, and knock on wood, that has not been the case for us yet. I actually think that our district court cases are lower for the last 18 months or so than they have been in the past 5 years. I don't expect that to last, of course. And we are, preemptively adjusting our budget to compensate, because like dollars that used to be ideally used in the past to resolve issues at the PTAB are going to have to be diverted to more and longer lawsuits at the district court.
Yeah, I would say the numbers for Verizon are going up in terms of district court litigation, and the vast majority being in Texas. And so definitely are spending already more on district court litigation. I would say from, the perspective of, how are we changing our approach? I think, looking to ex parte re-exam, which is cheaper, it does make it more accessible. It's easier to get, approval to go that route. But there's also no statutory timeline. And so there's completely unguaranteed timing on when you'll get a decision. And so with the increase in EPR filings, that means that, it's just not as likely to move the needle of a trial outcome. And then and the other thing to keep in mind about EPR is that, once the ball's rolling, you can't do anything to stop it, unlike an IPR. So, there's a question of whether or not the result of the current changes are that patents will be preserved overall, or if there's going to be more EPRs kind of already in the mix, and there's nothing you can do even after you settle the litigation. And then I would say the last thing is that there's just going to be more settlements that occur, that licenses get paid on ultimately invalid patents, just based on the timing of litigation as compared to the EPR, and that cannot be good for our economy.
Agree completely. Settlements are going to go up, small dollar settlements in particular. And that also like sort of affects budget and planning because we're going to have to move money to settlement reserves and uh, more spend will happen up front doing sort of like early merits analysis and freedom to operate kind of assessments rather than, merits litigation.
Thank you, Lisa and Wakola. So, kind of maybe taking a step down into the more nitty-gritty, has there been any specific aspects of the new discretionary denial process that's been particularly impactful on your decision making as in-house counsel?
For me, I think it's settled expectations. I mean, it's so strongly skews it in favor of patent owners, that some of the other rules, like the one and done rule or the claim construction changes, are just more irrelevant because we would often decide not to file the IPR in the first place just based on settled expectations. Interesting, this morning I heard Deputy Director Morgan Stewart talk about settled expectations and situations that were not settled expectations. And one example was where if a plaintiff starts asserting in a different industry, and she had several examples, and I was just really struck by how they were all such complete edge cases that have never ever come up in my time at Roku and when I was an attorney at a firm either. Um, so although on paper settled expectations are you can work around them, it's the situations where you can are non-existent.
Yeah, I'll just piggyback on that, settled expectations. That because this, doctrine or theory is so new, petitioners didn't really get much notice about, how to make this argument and how to, to tell the other side of the story of the settled expectations story. Um, because it's a narrative that really focuses on, the businesses that own the patents that are being asserted and doesn't consider that the businesses that are making products, providing services, should get well set expectations as well in terms of how much they've put into time and money and effort to build, release, and market a product. And they do this publicly for a decade. Say, why shouldn't they have settled expectations of the products that they've put into the marketplace? So that's the quandary when it comes to this new consideration. It only tells one side of the narrative, and fails to address many different sides of the story. It falls silent on the NPs asserting invalid patents. It ignores that businesses frequently find themselves sued because they make a product that dares to be successful. It fails to address the fact that perhaps the patent office didn't make a mistake, but rather the patent was valid. It included a valid idea, but then after the patent changes hands a few times, the scope all of a sudden is much broader than what the examiner was ever examining. And so now you have this new thing that is being asserted, and the patent office didn't make a mistake, but rather there's some overreach happening, and who's in the best position to say what was really granted, like to define the limits of what was granted and what should have been granted. It really is the patent office. The district court judges are always hesitant to do it, and they kind of punt it to the juries, and the juries are like, well, who are we to decide what the patent office did? So
Yeah, and I have to agree with everyone else. I think settled expectations is clearly the big one, the elephant in the room, just because it's brand new, and it seems like it sort of eats up, like a lot of the cases just get eaten up by this idea of 6 years settled expectations. It, hearing some of the talking earlier today, it feels like I can see scenarios when, you've been asserting a patent in an industry for 6 years and, you've fought back challenges before, like then you have settled expectations. But I think in a lot of these cases, it's, a patent assertion entity that bought the patent from someone else, after it had been sitting around for 12 years, doing nothing, and then starts asserting it, against everyone in an industry. And it's hard to say that, everyone would have that anyone would have had a settled expectations that, these patents were going to get bought up by a big NPE and started being asserting against everyone. So I think it's one of those things that, like, of course, if you have settled expectations in something, you should have some expectation of being able to assert your patents, but it feels like it's just been way over broadly applied.
So, because given that, are there any situations when it does still make sense to file IPR petitions?
Sure, there's like hypothetical situations where an IPR would still be like make sense, if the patent has never been challenged before, when there's no parallel litigation that's gonna get to head first, maybe a low value dispute where you're not worried about giving up your 102 and 103 arguments in the district court. But practically speaking, those are never the case for us as a defendant. Like those are literally academic scenarios where yes, this IPR could be successful, but
So I'll say that, Lisa touched on this also, but there have been some expressed openness on the part of PTO leadership to hearing other narratives and to considering other narratives when it comes to well-settled expectations in particular. And while we're hearing from our, um, you know, patent experts, from our outside counsel, excuse me, that they're making those arguments and it's not moving the needle. I think that, if anything we learned in the last year, it's very easy, with the stroke of a pen to change policy. So, you know, currently the decisions seem to be focusing on, the well-settled expectations of the patentee alone. But I think that, I can only continue to hope that that pendulum will swing back in the coming months, if not the coming years, so that they do take into account some of these other narratives and some of the, the fact that, many of these patents have changed hands multiple times and never been commercialized by any of those hands. And so how does it then promote innovation to allow those patents to be unchecked?
Yeah, and I think that the numbers sort of I was talking about earlier about people switching from, the severe drop in IPRs being filed in the last quarter of 2025 and the increase in ex parte re-exams shows you that people are not seeing at least many situations where IPRs still make sense. And I think a lot of that's been discussed today already. It's, they're pretty expensive. Even if you get half your money back because it doesn't get instituted, especially these days when you don't even get an opinion of any sort, I mean, that money is just totally gone, right? Without getting anything back for it. So I'm sure there are scenarios where you can concoct a reason why you'd want to file an IPR these days, but it definitely seems like a lot of things have to be sort of look correct to you to make it worthwhile, as opposed to filing something that's much cheaper, like an ex parte re-exam, or just just fighting it out in district court.
So a lot of the previous panels mentioned that there's been a loss of predictability, given that these changes are happening so fast. So I'd love to know from an in-house perspective, how do you approach planning and budgeting when the PTAB landscape is evolving so quickly?
I mean, well, it's certainly evolving quickly. I don't think that predictability has changed. And in fact, I find it more predictable in that it's much more likely that your IPR is going to be denied, and therefore much more likely that you're not going to go that route to begin with. So it does give you predictability in terms of budgeting and planning, in that you need to plan for that district court litigation to go all the way, or you need to think about settlement risk more significantly early on. So, in some sense, it helps with predictability.
Yeah, I'll say that, predictability is valuable, but if it's a predictably bad outcome, it's not so much what I'm going for. So
So with, IPR institution rates plummeting, IPR obviously has become less attractive. So if you've been sued on a patent that you think was granted in error, what's the next best option after IPR to challenge the patent? The EPR, something else?
We've used EPRs to good success a lot over the last 5 or 7 years. And sometimes concurrently with IPRs, like, if we file some IPRs and, especially in cases where there's been a lot of patents asserted, sometimes, it's up, challenge some by IPR, some by EPR. Sometimes we use EPRs when it's something like double patenting. You can't, you can do the IPR for. But now it'll probably be more of our first line of defense would be to go with an EPR.
I can say that I know that, I mean, at Unified Patents, we mostly switched to ex parte re-exams a couple of years ago, and have had some good success there. I think, and I don't have the numbers in front of me, but I think that the numbers suggest, a similar level of claim invalidation. There's obviously some positives and some negatives, right? The positive being that the filing fee is much cheaper. Um, but the negative is it's ex parte, right? So to some extent, you're filing something, you're putting your best foot forward. You're trying to, um, you know, you're trying to see what arguments could be made by the patent owner, but you're not going to get to respond to those arguments. Um, so you never know what'll happen with a examiner who, and they tend to do a very good job, but like with all like with all examination at the patent office, the examiner doesn't have unlimited time. They're not, at some point they're gonna they might get sort of beaten down by if you make enough arguments, you might, do enough interviews, you um, do enough of that kind of stuff.
yeah, I mean, we haven't really come up with a clear strategy, and IPRs were not at all an automatic thing either. So, assessing each case one by one, and then also continuing to watch what happens with the pace of EPRs. I think that's going to be an extremely important thing to watch as the number of EPRs that get filed increase. My understanding is that they've, more than doubled, last year. So as those numbers continue to go up and, with fewer examiners, how long is it taking to get decisions there? And so that's going to inform our process going forward.
Yeah, I think some of the earlier panels mentioned that the EPR filings have doubled, but they're now less than 50 examiners. So it seems like EPRs will be taking longer in general. Um, so I guess recently the office proposed some new rules regarding institution of IPR proceedings. There was some discussion earlier about those new rules, and they include things like mandatory stipulations against parallel litigation and discretionary denials for previously adjudicated claims, which some people have called the one and done rule. So during the comment period, the office received over 11,000 comments in response. And I think Unified Patents looked at basically all 11,000 comments. And so Jordan, kind of what did Unified Patents find when they looked through all those comments?
Yeah, so basically when they looked at, I can't take any personal credit, but our data team, which is great, put together the numbers, and we looked at all of those comments, all the 11,000 comments, and found that 97% of all the comments filed were in opposition to the NPRMs, at least as proposed. And it ranged from pretty much all of the major automobile manufacturers to all of the major high tech companies to I think like 12 plus semiconductor manufacturers, um, all coming out against it. And a couple of the themes that we saw over and over again were, the biggest theme was a desire for a patent system that prioritizes patent quality and petitions merits over discretionary factors. I think we found that 50% of all of the comments mentioned either merit or quality and were opposed to the rules. I think another big thing that was mentioned by 10% of all the comments that were opposed to a rule were helping out small businesses. And one of the other big things that came up was increasing that it would increase prescription drug costs. I think Joe Mattal was talking about that in one of the previous panels, but there were a lot of comments um, that basically making it much harder to challenge these patents would have the effect of increasing prescription drug costs. And the last thing I would say is that a lot of people suggested it would have negative consequences for software development and software development investment.
Lisa and Bucola, I'm sure you've looked at the rules. Do you have any perspective on kind of how you think it would affect maybe predictability or something else based on your perspective?
We submitted comments to the rules like 11,000 other entities. And I think our comments echo all those that Jordan said. But one thing in particular, I think was like the mandatory stipulation, I think is a rule breaker for us. If the IPR is instituted, you have to say you're not going to pursue any other 102, 103 defenses of district court. And that's just not workable for companies in to go into this all or nothing choice so early on in a case, well before any discovery has happened. At that point, we probably don't even know if we potentially infringe the claims or not. So like it's really hard to sign away your potential defenses. I'm trying to think back to the comments that we made, but really I think it echoes those that Jordan highlighted. Overall, the rules strongly favor patent owners and as a whole disadvantage operating companies. And I see a lot of chat comments are insinuating that Roku hates patents or is out to get the small patent owner, and that's not the case. We have a very strong, innovative patent development program in-house. We have a large patent portfolio. We love that our engineers are inventors, and we still felt like these rules are not helpful for us.
Yeah, and I'll just say that, again, a particularly bad outcome is not really what we're hoping to see. I think that it's difficult when you say like the one and done, if there's a smaller company with a lot less at stake, files something challenging a set of claims, but then later, there's much more at stake. I think it makes sense to spend more to look to see if there's if you've really found the universe of things. So I think that there's just it's looked negatively upon that larger companies can spend more money on something. And the reality is, we don't typically spend money on things that are not, really worth the expense. So there's not like a sense that, just killing patents is like this really fun thing that, benefits
Right.
for us.
Let's find a patent and just go kill it. Sure. Take
Like,
that, small inventor.
That's just not a thing. If it's being asserted and you're winning hundreds of millions of dollars in damages, then yes, there needs to be an investment in figuring out if that's the right result. So I think that that's what I would say about those new proposed rules. I think what would bring accountability and predictability that in a healthy way is to issue opinions on every decision. That'll bring a true sense of like what it is that you're deciding and on what basis. And then I would just say that from a bigger picture, better predictability would come with us the industry kind of advocating for more statutory reform so that the pendulum can't swing so wildly each time there's a change in administration. it just makes sense that, that the balance should be struck by Congress, and then we can kind of work within those parameters rather than having a completely new set of thoughts and ideas every time.
All right, thank you for those thoughts. All right, so note that many of the new discretionary denial procedures have been challenged through mandamus petitions to the Federal Circuit, and most of those petitions have now been denied. Do you see stakeholders continuing to challenge the office's new policies, and if so, how?
I mean, the PO has a lot of leeway with how it administrates the procedures that's in their purview. So it's very difficult to, to challenge that. But I guess what the PTO has demonstrated is that, it is easy for the PTO to change course. So continuing to kind of advocate and present new options and kind of test the boundaries of some of the things that the deputy commissioner has mentioned as, scenarios that wouldn't qualify for the discretionary denial, and try to find kind of, the magic pathway to getting access to IPRs again.
Yeah, I
All right.
mean, I'll just add that I certainly don't foresee what the big avenue for challenging the procedures are. I think what we're seeing and what you're likely to continue to see is just fewer and fewer IPRs being filed. So there won't be as much to challenge because people aren't filing the IPRs.
Right. And so before we move on to some questions, Jean, did you have anything to kind of add or question to ask of the panelists?
I do not necessarily. There are some, I think, some pretty good questions that are coming into the box.
Yes, I was
I don't know
definitely
whether
into
you've had a
those.
chance to keep up with them. I can pitch one over to the group if you want.
Yeah, I've been keeping up with them. So let's, I think a good one was, have you seen any changing behaviors from NPEs given the PTAB changes? And if not, kind of what changes in behaviors do you expect?
I think I kind of mentioned it. We are certainly expecting to have more cases filed by MPEs, and haven't seen it yet, but expect it to happen, within the year, certainly. And we would also expect those cases to be filed at more rocket docket venues like EDTX and WTW, Western District of Texas, sorry, where, that's where things are filed a lot now anyway, but I expect it to skew that way even more. I don't know of any other changing behaviors, Bukola, anything?
I think the damages question is one that we are kind of grappling with. I think that, we're just finding that overall damages asks are going higher and higher and higher because there are very few checks on NPE litigation at this point. So that's kind of the area that we're seeing a lot of change in behavior. And we're hoping that, that's going to be something that gets addressed by the Federal Circuit in more clear ways.
I'll echo what Lisa had said. I think the numbers show that there definitely is more NP activity already last year, and I would expect that this year there'll be even more. I've seen some suggestion that it has sort of emboldened litigation financiers in the IP area as well, right? Because if you can assume that there won't be an IPR filed, then you're much more likely to get further along in the trial process without having to worry about the patent being invalidated. So I would expect that to sort of lead to more cases and, like we're saying, possibly higher damages asks, etc.
Yeah, could be a whole day's discussion on skyrocketing damages asks.
Yeah. So Scott, I did have a question actually as you were answering that. Lisa, I think you mentioned that you are seeing a lot still of these what I would refer to as just nuisance cases. Can you give us a sense of like what that magnitude is, both maybe in terms of what amounts that they are trying to hold you guys up for, and how often does that still happen?
Yeah, I mean, I would say every couple of months we get sued or an assertion, with a draft complaint or, like say, hey, this complaint is coming. And lots of times it's sort of ankle biter
Mhm.
trolls, by the well-known plaintiff law firms out there, and they often are asking for less than $100,000 and pretty hard to it's pretty hard to engage outside counsel to even evaluate a patent for less than, you end up paying just because it's not worth the legal spend to investigate and defend it fulsomely.
So have you given and because I find that just that is the problem I thought we were trying, and I mentioned this in the last panel, thought we were trying to solve when we had the AIA, and that group of people seems to be the only folks who have not been affected by the PTAB at all. And it seems like there should be a solution there for that. And I mean, I wonder if any of you have given any thought as to what a potential solution would look like for those. And I like how you call them ankle biters, because it's probably a better term than what they deserve.
I mean, I don't have a solution in mind, unfortunately.
Yeah, that's the problem. I mean, because there's just not enough money involved, because the fees are going to be what, around 50 grand just to start an IPR, just the fees.
Yeah.
When there's got to be a solution. I mean, there has to be a system-wide solution to at least deal with those actors who are just, in my words, just those are the ones that the district court years ago referred to as this extortion artists, or extortion-like, is I think how they described it. And I don't know. I keep thinking about it too, and I don't have a solution either. I don't know whether anybody else does or not, but I'll recede back into the background and let you take over again, Scott.
Thanks, Gene. Yes, a couple more questions. This one's kind of interesting. It's about freedom to operate analysis. So the question is, so for patents with settled expectations asserted by NPE litigations, like, do you think those patents potentially could have been identified by freedom to operate analyses kind of during your company's product development? And maybe could those patents be challenged earlier, prior to the cost of litigating against the NPE?
I would,
Interesting question. Go ahead, Bukola. I'll think on this a little bit.
yeah, I would say no, because the way that one of ordinary skill would read the scope of the patent is different from the way that they're being asserted. And so when you have, an analysis and you look at a patent and you say, oh, this is what they invented. I get that. That's not what we're doing. And then you still get a litigation that's going to argue really hard that it is what you're doing. There's just not a way to do a freedom to operate around that.
Any good attorney would say, yes, you're free to operate. Go
Yeah.
ahead.
Yep. Any good attorney. Yes, absolutely.
Yeah.
I,
It's interesting. Like we don't go looking for patents that we may infringe, because that's been our experience completely, also because the lawsuits, or sorry, the patents that are asserted against us are stretched beyond their reasonable bounds so far that, like, you wouldn't find that as a rational attorney reading a patent. You're like, okay, this is for, this is old-fashioned broadband TV. That certainly doesn't apply to Roku. Oops, we got a lawsuit. It's just uh, stretched beyond belief. But on the other hand, we and many operating companies do not freedom to operate necessarily, but are aware of the patent landscape of, standards and patent pools and things, and are actively take part in those and take licenses to um, video codec standards and things like that that are fundamental to our business. So, it's not like we ignore the patent world and hope for the best. It's, we do what we reasonably can do.
Yeah, and this is kind of a follow-on question. So with the PTAB encouraging the use of PGRs, which might apply in the freedom to operate analysis phase. So how often is a PGR a viable invalidity strategy for your circumstances?
It's not for us.
Yeah.
I mean,
Okay, I think we have our answer.
I think the timeline is just so quick after the patent is issued that, um, and I just wanted to hop on to what Lisa was saying earlier. I think a lot of the patents that theoretically, that theoretically you could find in a freedom to operate study are not really directed to the same technology you wouldn't think, but they're just overly broad. Like I think a part of the problem is that, the patents that are, that we would see as the AIA would sort of see as bad patents or are these overly broad patents that got granted, even though there's prior art, and that's what you would theoretically want to challenge, but it's hard to just go after and say, oh, it turns out that, because this patent just ended up with this one broad claim that I should have seen it coming, um, you know, 10 years ago.
Right. So Jordan, this actually might be the next question you probably best situated to answer. Are you seeing any common threads as to what petitions are being discretionary denied without comment in the last 3 or 4 months?
I I don't think I've seen I don't think I've seen anything that sort of went into that. Obviously, given that there's no opinion, it would have to be a pretty deep dive to go in and look at all these cases to try to figure out if there's any theme, from the petition itself, I guess, because you're not going to get anything anything else.
All right. So, okay, here's a more of a thinking outside of the box question. So, would you rather keep the patent system as is or abolish all patents?
I'm sorry. Can you repeat that?
This is, would you rather keep the patent system as is, like the current PTAB, MBE litigation, et cetera, or simply abolish all patents? And the questioner says, I assume big companies like Verizon and maybe even Roku might prefer to abolish the patent system altogether, but it'd be interesting to get their opinion.
So I cannot speak on behalf of Verizon, but I'm not aware of anyone advocating to abolish all patents.
Yeah, same. I personally do think that the patent system helps promote innovation and works generally as it is supposed to do. Um, I think that it was some of the judges earlier who were making the point that the number of patents that are litigated is minuscule compared to the pool of innovation overall. And so I think that's the proof that it is working. People are inventing and innovating in all fields, and a tiny amount of them are litigated and fought about at the PTAB, but overall it's working.
Yeah, I mean, personally, I agree with what my colleagues were saying. I wouldn't want to get rid of the whole patent system. I think it generally works pretty well. I think what we're arguing is sort of patent quality on the margins.
Right. I think probably one final question for the panel. So if Director Squires were watching this panel, like what would you want to tell them from where you sit in your in-house perspective?
So from what I understand, the current policies are working as intended. So questionable whether or not there would be anything kind of gained from making this statement. But if I go along with this hypothetical, I would say, I would urge PTO leadership to consider the needs of the entire constituency. Most frequent defendants are also frequent patent holders. So innovation is not only happening on the patent assertion side of things. So please consider the needs of the entire industries that are affected, not just sort of a reactionary overcorrection to a very specific scenario. That's, something that I think that just isn't being addressed by the leadership right now. Like, what about the other scenarios? And the other scenarios are the ones that are just much more commonly experienced by companies like Verizon. It's the PTO's responsibility to address overreach by patentees, not just correcting whatever it deems to be mistakes by the patent office. I think that, there's often a drastic disconnect about what was actually patented. And so the PTO is in the best position to assess the validity of what the patentee is now asserting and now is claiming is an issued patent.
Lisa, Jordan, anything?
I'm sorry, my son who's been home for for snow with day 5 of snow days in a row here in the DC area ran in, and so I totally missed the question. I apologize.
Sorry, basically, if Director Squires were watching this panel, what would you like to convey?
Yeah, I mean, I think now hearing the question, I think Bukola is correct. Like, I think that's pretty much dead on to just, make sure, and I think that goes for everyone who's leading the patent office to try to strike some sort of a balance between, the two sides as we see it. It doesn't need to be, it doesn't need to be patent owners versus petitioners. There has to be some sort of a balance that we can reach. Because, like she was saying, I mean, um, there's obviously NPEs and then, other entities, but most entities are patent owners and, also get sued for potential patent infringement. So there's got to be some way to thread the needle a little bit better.
Yep, agree completely. A functional IPR system can help promote and protect innovation just as much as the patent prosecution system. But at the same time can reduce unnecessary litigation and help reduce litigation costs for operating companies. So I think we can strike a functional balance, and hopefully we'll get there.
All right, well, thank you. And thank you all for your very thoughtful comments. And Gene, I think we're ready to wrap up.
Yeah, sure. And I really appreciate your comments. I have maybe one more just general question, just like how often, to the extent that, and if you think this is an unfair question, please just tell me, but how often do you see patents that are just what you would refer to as, just bad, versus ones where there's a legitimate disagreement as to whether this is or should have been issued, or it is or infringed, and it really does require a jury and a judge wearing black on either the district court level or the PTAB level to make a call. And what's the order of magnitude of again, trying to get at that bad act, what I would refer to the bad actor one. And maybe Lisa, to the extent that you can talk about it in terms of, because I'm a big fan, I've shared this with you in the past, I'm a big fan of Roku. I mean, I love Roku. I think it's a great technology, but it's not analog technology. So if you have an analog patent and you're trying to enforce that against Roku, well, I mean, maybe you could stretch the claims to be that, but that would only be because it was written at a time when Roku didn't exist. So how often do you see that kind of situation?
It's a good question. I would like to think back and thoughtfully look at my cases recently and decide what, how I would judge them, but just kind of spitballing, I think it's about 50-50. 50 you're like,
Really?
that's an interesting patent, and this is a tough case, and 50, what a piece of garbage that we're wasting millions of dollars on. Yeah.
Mm-hmm. Bucola, is that about yours 50-50, you think, or is it? And not holding you to this. I'm just trying to get it like in order of magnitude, because one of the things I think about when we're talking about all of these things, for most people, and there's always the 10% on one side and there's the 10% on the other side, and the 80% of people in the middle have, I think, positions that are reasonable based on the set of experiences that you have as your reality. So I always try and get, well, what's the reality here? Like how much is this a problem? Because like if it is 50-50 for everyone, it's easy to understand why companies are jaded, and it's easy to understand why they're upset. Because that's a number that it shouldn't be. And it seems like then the judicial process is being used to hold people up in ways that they shouldn't be able to be used that way. And so,
Yeah, I would say 60-40. 60 would be cases that are either the patents are poor quality or the arguments are poor quality arguments. So everybody knew what they were talking about when it was being patented. The patent office knew what they were talking about. The inventor, the original inventor, knew what it is that they were talking about. But that's not what's being asserted now. What's being asserted now is what is the broadest that we can expand the meaning of these words to cover what the entire industry is doing. And that's the majority of what I'm seeing.
okay. Jordan, your thoughts on that?
Yeah, I feel like the example I always use when I'm talking to like lay people who aren't in, the patent space, I feel like for a while we were always seeing patents that were clearly designed to cover pager technology, and they'd be like, "Oh, we invented the iPhone," and you're like, because it'd be like it has a screen that like, and you're like, well, sure, it has a screen, but like, I feel like. And that's sort of what I was trying to hint at earlier with some of these like bad patents that are just somehow they got through with like, one claim or a couple claims that are just crazy broad. And you're like, no one was thinking of that at the time. But then, 10 years later, you're like, oh, actually, I think, this claim actually applies to every smartphone that anyone's making. And I'm sure there are other examples in all of the various, especially high-tech industries, but anywhere, it's just I agree with what other people were saying is that I don't think the examiner was thinking that. I don't think the applicant was thinking that at the time. I think sometimes you just end up getting lucky. I mean, like getting these claims that broadly like could read on technology that you were never thinking of, you didn't disclose, no one was thinking of at the time.
Right. And I wonder, and this again is maybe not a as fair a question. So let me just put it out there because I think I have a concern. And if you want to follow up on that, then please feel free to. But I think when you look across all areas of law, the more specific the rules, the more specific the laws get, the more susceptible that they are to engineering, creative engineering in ways that are really not intended. So in one of the ways I think that applies to this conversation is, back in the day, back before any of us were part of this industry at all, patents were 1 or 2 pages. And the claim was, I claim what I have just described in that it is a wheel that goes round and round attached to the front spoke of a bicycle or something like that, right? So I wonder whether we would be better off going back to that type of claiming and that type of patent drafting, because in those older patents, you can't read it and not know what was invented. Everybody knows what the inventor invented, but now we have all this patent claiming is like it's its own language, and it's when I teach patent claim drafting, I'm always like the 3 most common words in the English language, the, a, and an are all terms of art. I mean, who makes that rule up? I mean, that's just idiotic. The 3 most common words in our language are terms of art for us, and I think we've gone off the rails. I think we've jumped the shark, and I think it's the courts, the more that they try and say, okay, this, not that, I don't know what you mean, this, that, then we get more and more and more and more layered of rules, and then you wind up with somebody, in one of the cases, this is now probably 20 or so years old, it was clearly a wired technology, and they were using it, and it may have been against like a Dish Network or DirecTV, and they were trying to have it cover wireless technology. And the Federal Circuit said in that case was as well, technically the claim could be interpreted that way. Well, I suppose, but wireless technology didn't exist when this person filed that application. So how could it possibly cover what DirecTV was doing? And so I don't know whether you have any thoughts about that or about, what would streamline, make it easier. Because I what I'm hearing you say is that you're in favor of the patent system. You think it helps. You think it promotes innovation. You just don't want it to get in the way. So how do we do that?
Yeah, I mean, I think that you have access to the PTAB. And if you want to create an enablement body that's going to reassess enablement of the patent claims, I would welcome that as well, because that's the issue, is that, it is a validity question. If you're saying that the scope of the patent is this wide, when really all you talked about in your patent is what's this wide. And so that's an enablement issue. It is a validity issue. It's all of the above. So if there's more bodies to assess, how to, and that's what makes, patent prosecution processes work better, is if you have accountability on the other side. So if patent prosecution professionals were seeing the decisions coming out of the PTAB, seeing decisions coming out of some viable way of testing enablement, there really isn't one, then they would be able to adjust their practices accordingly. But because of this pendulum swinging wildly, it does make sense why claims are drafted the way they are now.
Yeah. No, I mean, I get it. I'm not trying to throw any patent prosecutors under the bus. I mean, that's what I spent most of my career doing, and I get why they do it, why it happens. I just wonder whether it's the best approach. I hadn't really thought about it being maybe what we ought to be doing is and maybe to the exclusion of exactly what we're doing. Maybe the PTAB should be looking at 112. And, not trying to pound this, like 8-way obviousness, rejection or invalidity argument, when in fact what it really is you're dealing with somebody who's trying to use this in a way that nobody ever intended it or thought it would ever be used.
Yep.
Interesting. Absolutely. Well, that's really all I have. I mean, if you have any final thoughts, and Scott, I'd love to get your final thought on all of this too, because I know you do frontline stuff for folks much like you are in the panel, and maybe in the time we have remaining, since you haven't really had an opportunity to contribute too much, you've been doing a good job with asking questions. I'll ask you, what advice are you giving your petitioner side clients now?
I think just look very carefully about whether there's a chance your IPR petition would be successful. Like previously, it was almost automatic that if you're sued on a patent you think is not worth defending in district court, you would file a petition. And now I think you have to go and do a lot of upfront analysis based on settled expectations. What's the timing of the litigation? Whether there was examiner error. There's a lot of now new upfront analysis that goes into prior to deciding to actually file an IPR petition. And so I would just say, look carefully prior to deciding, do I do IPR, ex parte re-exam, et cetera.
Okay. Excellent. Well, good. And I managed to get us along over the hour. So everybody will get a free CLE hour, and the panelists, you will probably be able to multiply that by 3 in the jurisdictions that you are in. And I really appreciate you all being here today and pivoting with us as we moved virtual. Thank you so much.